A very good afternoon to all of you friends. A very good afternoon to each and every one of you out there. So friends, welcome to BYJU'S Exam Prep. Welcome to your last lap for your preparation for AILET 2022. Since AILET 2022 will be a very important examination for each and every one of your life, here from BYJU'S Exam Prep, we bring to you a fantastic session on your preparation. How well is your preparation? Where are you lagging behind? Where are you successful in overcoming your difficulties? That is what we are precisely going to see in the course of this particular session. So a very warm welcome, a very good afternoon to each and every one of you watching me live across India. Today we begin with your preparation for AILET 2022, rather a kind of a revision. How well you have studied in the last 1 year for your preparation for the big day. But before we start with today's session, let's rather see what are the important stories or those pointers that we must all remember. Now, let's first look at the important dates. May 25th is the last day to fill your application form for AILET 2022. So this particular date is a very important date for you guys. May 25. AILET exam is scheduled on June 26. So these are the two dates. Now let's now try to understand the kind of questions that AILET gives in this particular entrance examination. So from English, you have 50 questions, 50 marks. Current affairs, 30 questions, 30 marks. Logical reasoning, again, you have 70 questions. And in total, you will be having 150 questions comprising on 150 marks. But the most important thing that I must tell to each and every one of you now is that the duration is 90 minutes. So 90 minutes to answer 150 questions. That's very important. Now, for every correct answer, you get +1, and for every wrong answer, there will be a deduction of 0.25 marks. Now, is legal reasoning still important or significant? Yes, as per the notification for CLAT, legal principles may be used in the logical reasoning section. So since legal principles will be used in the logical reasoning section, it will become absolutely important for each and every one of you to have a decent idea about about AILET, legal reasoning. Now, legal reasoning might not come in those typical form which they used to be. Now, but legal reasoning principles, the legal principles will be used in the logical reasoning section to test your legal aptitude. Now, AILET in its notification says that they are scrapping with the legal reasoning section. But please do not fall into that line of prey. It's a dangerous word that AILET has used. But they say, to clarify its position, AILET has very categorically stated that they are going to use those legal principles in the logical reasoning section to understand your legal knowledge, your technical understanding of law, and henceforth. So you cannot just ignore legal reasoning question. So you must prepare for it. Now, what are the important things that we have realized? The expected structure of the logical reasoning section, okay? The expected structure would be from the critical reasoning section. They will ask you around 17 to 20 questions. From analytical reasoning, around 12 to 15 questions, and from the legal reasoning section, around 30 to 35 questions. So this is probably some of the most important things that you must remember while we are preparing for this particular entrance examination. Now, mathematics may or may not appear in this examination, but in the logical reasoning section, please do not be surprised if you get legal reasoning questions. Okay? So guys, let's move. Another certain important facts that I would also rather want to speak to you about, that if two or more candidates gets the same marks, if two or more candidate gets the same mark, then it will be very important for each and every one of you to rather understand that in the merit list, your scores will depend on the logical reasoning section. So if two or more candidates gets the same mark, if two or more candidates gets the same mark in the AILET examination, the merit list will be determined based on the logical reasoning marks. Very, very important. So that becomes absolutely important for each and every one of you to understand. So it is clearly mentioned in the notification. So the tiebreaker will be the logical reasoning section for each and every one of you. So in the past years, let's say 2020, 2021, what was the trend of the legal reasoning section? So let's understand the kind of questions that AILET has asked in 2020 and 2021. So these are the various topics of law. So from contract, they have asked in 2021 11 questions. In 2020, just 7 questions. Constitution, 6 questions, and in 2020, just 3 questions. Law of torts, 6 questions in 2021 and 8 questions in 2020. Now, in 2020, they did not ask a single question from law of crime, international law, or property law. But in 2021, they did ask certain questions on law of crime, 7 questions in 2021, 2 questions from international law, and 1 question from property law. But in 2020, the major difference that we saw in relation to 2021 is that legal GK. In 2020, you see, the 17 questions came from legal GK, whereas in 2021, just 2. Very, very important. See the difference. So, what can we predict in 2022 to happen? You might predict, you might get some mixed bag like 2021, or there might be certain questions from law of crime, international law, property law. Now, AILET, the kind of questions they have given in the previous years must be considered very well so that you are able to give this examination with the best of your ability and knowledge. So let's practice some questions. So guys, let's start practicing some questions, okay? Let's do it. Let's do it. The first question is up there on your screen. Read the principle very carefully. Where one of the parties to a contract was in a position to dominate the decision of the other party, the contract is enforceable only at the option of the party who was in the position to dominate the decision of the other party. That is the principle given. Okay. Now the doctor over here asks his patient that, I'll do the surgery for 10 lakh. The patient has paid an amount of 5 lakh and has promised that after the treatment, he is going to give the rest of the amount. After the treatment is over, the doctor demands the remaining amount. The patient refuses to pay. Right? Now please tell me the correct answer. Please tell me the correct answer. Was the doctor in a dominant position to influence the will of the patient? Did he apply any force? Not physical force, that would come into coercion. Any kind of force by which he pressurized the patient to fall? Please give me the correct answer, guys, please. Is the contract enforceable or is the contract not enforceable? Okay. Everyone says D. Very good, very good. I'm getting great answers. Okay, great. So the contract is enforceable against the patient by the doctor, because over here the doctor did not use any kind of undue influence, right? Undue influence. There was no undue influence in this contract. No undue influence. So the correct answer is option D. Moving on to the next question. Very good. A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable. So when he is entering into the contract, if he is capable of understanding it and of forming a rational judgment to the effect based upon his interest. Okay. It is clearly mentioned over here, Mr. Y, when he was of unsound mind, Mr. X, he enters into a contract. Enters into a contract with Y when he was of unsound mind. Now, is the contract valid? Let's see the correct answer. So, here is a person who, when he entered into the contract, he was suffering from unsoundness of mind. He was suffering from unsoundness of mind. Okay, please give me the right answer, all of you. Okay, Anisha says A. Okay, A. Okay, I'm getting. Atif says A. Tanya A. Hemant A. Asmita A. Shweta A. Okay, so the correct answer is definitely option A. The correct answer is definitely option A. He cannot enter into the contract because he was of unsound mind. When he entered into the contract, it is very categorically mentioned that when he entered into the contract, he was suffering from unsoundness of mind. Very good. So guys, if you are liking this session, or rather understanding this session well, how to answer these questions, please press the like button and do not forget to share this video with your friends who all are also preparing for AILET and other law entrance examination for the year 2022. Moving on to the next question, question number 3. Okay, so when one person signifies to another his willingness to do or abstain from doing something with a view to obtain the assent of such person to such an act or abstinence, he is said to have made a proposal. So the definition of offer or proposal is given on the principle. Here is a man who writes to the other friend of his, another person, Shyam, saying that, will you sell me your car? Telegram me the lowest price. The other person says the lowest price of the car is 20 lakhs. So he says, I agree to buy the car for 20 lakhs. Shyam refused to sell the car. Now, what is the correct answer to this particular question? Now, I'm sure that you have heard about offers are of various type. Okay, there is something called general offer. There is something called specific offer. There is something called invitation to an offer, right? There is something called invitation to an offer. Now, I go to a shop and I see a beautiful, magnificent sofa. And I say, what is the price of this sofa? He says, 20 lakhs. Can I just say that, here is your 20 lakhs, give me the sofa? No. No, you cannot. Very good. Most of you are giving me the right answer. The correct answer is option B. This is a case of invitation to an offer. Am I clear? This is what we understand as invitation to an offer. Okay? Am I clear? He can refuse to sell the car because it was only an invitation to an offer and not a real offer in that sense. Very good, very good. Now, 4, 5 and 6 will have the same legal principle and certain facts. Please read the legal principle. So, the legal principle that is given in this particular question from 4 to 6 is invitation to an offer. A tender arises when one party issues a statement asking interested parties to submit the terms on which they are willing to carry out work or supply goods. The person inviting the tender is simply making an invitation to treat the person submitting a tender in the offerer, and the other party is free to accept or reject the offer as they please. Okay. Okay. Let's move on to the next principle. Read it. Okay. The effect of acceptance depends upon the wording of the invitation to tender. If the invitation states that the potential purchaser will require a certain quantity of goods, acceptance of a tender will form a contract and they will be in breach if they fail to order the stated quantity from the person submitting the tender. A mere statement of invitation to sell is not an offer. Okay, so these are the three legal principles given. Let's move on to question number 4. Okay, so X made an offer for 10,000. Z has a bid of 20,000. The authorities accept the offer of X, 10,000, and rejects the offer of 20,000. The answer is pretty easy if you have understood the concept of invitation to an offer. Okay, I'm getting all the answers. C, 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 C. Okay. Let's see the correct answer. The correct answer is the action of the authorities is absolutely legal because it is up to me whom, suppose I want to sell my house. I say, I want to sell my house. Please send me your offers. Somebody says 10 lakh, somebody says 15 lakh, somebody says 20 lakh, somebody says 30 lakh. I sell it to the person who says 20 lakh, even though I got an offer of 50 lakh. It's up to me. It's my thing. Whom do I sell it? Whom do I not sell it? Depends on me. Right? So the action of the authorities is sustainable in law because it is up to the authorities whose offer to accept and whose offer to reject. Question number 5. Okay, so a private company dealing with electronics named X posted a tender for the purchase of certain spare parts for the tune of 5 lakh, but finally entered into a contract for 4,50,000. Determine if the contract is valid or not. Okay, let's see the correct answer, guys. A, B, A. Okay. So people are between A and B, A and B, A and B. Okay, let's see the correct answer. Let's see the correct answer. Is the contract valid? No, or is there a breach by the purchaser? The correct answer is the contract is perfectly valid. It is up to me whom to sell it for what. I say 5 lakh. Somebody says, okay, 4.5 lakh, final agreement. There was certain negotiation. No issue. You cannot challenge it on any count. So the correct answer is option A. Yes, the contract is perfectly valid as X company is not bound to sign the contract for rupees 5 lakh. Okay? Okay. Question number 6. So here is a furniture company which has placed an advertisement in a newspaper that certain items, including some office furniture, would be placed up for auction over 3 days. Nickerson and company obtained a commission to buy the office furniture and expend time and expense to travel to bid for the office furniture. On the 3rd day, the lot of the office furniture were withdrawn. Nickerson sue for the loss of time and expense, whether the claimant will succeed legally or not. Simple question, not difficult at all. So I say that I want to sell certain goods, and if you come, you can see the goods and bid for the price. You take time to reach, you spend 10,000 rupees on your aircraft charges and other expenditure, and finally you see that you got nothing. Can you sue me for your expenditure that you suffered while traveling? Okay, so let's see the correct answer. Most of you are giving me the right answer. The correct answer is option B, that is Nickerson will not succeed for the loss of time, money that he has spent. Very good. Very good. So you guys are enjoying it. Most of you are giving me the right answer, so I feel that you guys are well prepared. Let's come to the questions for 7 to 9. Terms and condition of an offer must be clear, definite, and certain. Certain, definite, and clear. In the terms of the offer are not certain or definite, it is not a valid offer. If it is not certain or not definite, it is not a valid offer. As to it not clear as to what exactly the party intends to do. Okay, the next question, principles. A social contract or a social invitation cannot be regarded as a valid contract. A social contract cannot be termed as a valid contract. And the final principle given over here relates to communication of acceptance. An offer accepted without its knowledge does not confer any legal rights on the acceptor. Very important. Okay, done? Very good. Let's come to question number 7. I think I have given you the answer to this question. I think I have given you the answer to this question. Okay? Okay, what is the correct answer? The correct answer is option A. Sorry, it is. I think there is some. It's not B. It is A. A is the right answer. Okay, this is not the right answer. It is not the right answer. The correct answer is option A. Okay, I think there is some error. Okay. Okay. Let's move on. Let's move on to the next question, guys. Question number 8. A and B, where both husband and wife agree to enter into a contract for a sale of property. Now, a husband and a wife is entering into a contract for sale of property belonging to the father. Now, an offer for rupees 50 lakh was made by A to B, which was initially accepted by her. However, later a person comes with a better offer, 70 lakh. Now, B wishes to reject the offer made by A. Now, is B legally correct? That is a precise question over here. This is a precise question over here. Let's see the correct answer. A husband wants to sell a property to his wife for 50 lakh or 60 lakh, whatever that amount may be. Is it a social contract or is it a proper contract, a legal contract? That is a precise question that needs to be answered over here. Now, the correct answer over here is she is legally incorrect. Very good. Most of you have given me the right answer. Now, it was a valid offer. It was a valid offer, valid acceptance, not something to do with a social contract, right? Very good. Very good. Question number 9. there is a reward. There is a reward that whoever finds the boy will get 501 rupees. But layman does not see this advertisement and has found the boy. Now, can he claim for that reward later? There was an offer. An offer was made. Was the offer accepted? Did he had a knowledge about that offer? He did not see the handbills where the offer was made. So the correct answer over here is layman cannot succeed as there was no valid acceptance of the offer. He had no knowledge. There was no knowledge of the offer. There was no knowledge of the offer. Since you do not have any knowledge of the offer, how will you accept that offer? The next question, question number 10. Where a minor enters into a contract with a major, the contract is not enforceable. I think I should not tell you the answer for this question. Is Animesh below 18? Yes. Can he enter into a valid contract? No. The contract is not enforceable. So there can be no claim on the basis of that contract. So option B and option C. No, Animesh is a minor and the contract is not enforceable. The claim made on the basis of the contract is not enforceable again. So the correct answer is option D. Option D is the right answer. Option D is the right answer. Option D, both B and C are the right answers. So, did you understand how to solve these questions? On the last lap for AILET 2022, these are the upcoming sessions. Please do join us. You will see me live again coming up with principle and fact-based questions on Law of Contracts Part 2 on 20th of May 2022. That is this Friday itself. So guys, do not forget to join us on June 19th for CLAT 2022 First Impression and Daily and Detailed Analysis. CLAT 2022 live analysis with the faculties. So we shall all be together. All faculties will be together on 19th of June to discuss the first impression and have a detailed analysis of the kind of questions we had seen. So do subscribe to our YouTube channel. Do follow us on our Instagram, Facebook, and definitely do not forget to join us on our latest Telegram channel. And just do not forget to download this particular BYJU'S Exam Prep app on your mobile phone. Okay. So with this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great day ahead. Have a great week ahead. All the very best for your preparation for AILET 2022. Goodbye from the entire team at BYJU'S Exam Prep.